Thanks, Geraldo.
Here, we're back on the record.
Okay, so what was your question again?
Oh, I was just, when you were referencing some doctor exhibit from January 30th, I'm looking at the filings from back at that time frame, and
Because he was in the hospital, and that's when I filed my ex parte motion. So it was at that same time. I filed one immediately.
yeah, but it was before the 30th, and so
I didn't get the records until the date of the records. When I got the records, were on the 30th. But
Okay.
we were in the hospital on the 29th when I filed that ex parte motion.
So yeah, so you filed a motion to keep Alicio. You said he was having impaction again, I think.
Yeah, so the ex parte motion on the 29th was because...
But I didn't have that record. You're saying that the court didn't listen to that record, but I didn't have that record.
I submitted it with the ex parte motion.
It couldn't have been because you filed your motion prior to...
Well, I mean, I didn't file that record, but I told you everything that was submitted...
No,
There's
you're
pleading
saying
papers in
you're
that
saying I
motion
disregarded
telling
the
you why.
record. I didn't have the record. Just saying.
There's pleading papers telling you why I was filing the ex parte motion.
I'm just telling you that you said I disregarded that medical record. I didn't have that medical record. That's my point. I was looking for it.
Not saying that you disregarded that medical record.
Well, you did. That's why my point. So you said that, and that's why I was looking for it, because I didn't recall seeing that, and it's not in here. So, and then from that point forward, you withheld Alicio. There was an order to return the minor child, and we set the evidentiary hearing, and then we held the evidentiary hearing later in the year.
So what I said was, once again, the blatant disregard for Alicio's health.
Okay.
Not because of the record.
Okay. Well, that you were saying that doctor made a recommendation, and that I disregarded it. I didn't know what the recommendation was. So, anyway, go ahead. But we still now are at a point where, giving you the 90% of the time, and you want supervised visits now, and I've given you the control over his medical care, and so looking forward, I guess I'm trying to figure out what additional orders need to be entered.
Well, that's exactly why, like, when I say I need to read this and go over it.
Keep reading. Keep reading. We only have so much time. I have a hearing at 11.
You didn't get.
So,
all right.
Keep going.
Okay.
It is 30-something pages long, by the way, because if you look at your document, that's how many pages. It's 44 pages long. I don't know what page you're on. But
we had a court date February 20th, and that was when you said...
Are you reading the document?
That's when you said there's no way that mom just not giving him the medicine or following the treatment plan.
Right. And if you gave me...
Whatever reason that there is no way, mom... This court still believe, February 2018's court still believe for whatever reason that there is no way mom isn't giving meds or following treatment plan, even after this court was given an insane amount of evidentiary support of the facts, which leads me right into the next topic. The defendant's lies that can be proven. When the defendant claims on one of her bullet points that they never believe that I give Alicio his medications and would give him more because they don't believe Alicio when he states that I gave it to him already. They double medicate him. I don't need to infer any more on this statement, seeing as everything I just covered with all the medical records that clearly the defendant was not following the treatment plan, because it is documented on numerous occasions by specialists. Alicio's body tells him he is not following the treatment plan. There is no need for me to infer any different than what the doctors relay to me. When it comes to double medicating statements by defendant, and how does that even make any sense? It makes zero sense. If Alicio was being double medicated, he most definitely would not be having any medical issues right now.
Is he having any right now?
But it's okay to double medicate him.
Pardon?
I said, but it's okay to double medicate him.
There's a record of that. Yeah, it is, actually.
But why wouldn't you believe Alicio when he would tell you that I already gave him his
Save your
medicine?
questions to the end, please. Do not interrupt me.
Do not talk
please.
to her. You need to direct your comments.
Can you please not let her
Both
interrupt
of you guys
me?
need to stop talking to each other.
She just told you, talk to her.
So, what page are you on? I lost the
7.
page. Which one?
7.
You're not gonna be able to finish this if you're gonna try and read every single one of these pages in. It's just 7.
Just
so
reading
hold on.
some.
1, 2, 3, 4, 5, 6, 7. That's 18 of 40. 18 of 44 of the filing. So, go ahead.
Just reading some of the defendant's
Did you write
statements
this?
to this court.
No.
in
Did you
hopes
write this, Ryan?
He did.
That's
Did you
that
write?
doesn't.
Did you
that's-
write this? Well, typically,
does
if
that
someone
matter?
else writes it, they're supposed to sign it as the ghostwriter. If someone else writes it for you.
We both went. We both wrote this together. We
Who's
both
you
went
both?
over everything. Me and my wife Nicole.
Oh, okay.
We both went over everything,
Okay.
and we both wrote this together.
Mm.
Just reading some of the defendant's statements to this court in hopes that this court will keep disregarding Alicia's health based off her and Rosenblum's statements, words, and opinions that neither one of them are qualified to make. Instead of the facts of the doctor's records, this court stated that my wife should be excluded from doctor's visits, and that if I cannot bring him to the appointment, then the defendant should be the one that takes him to the appointment and relays information and records to me and this court. Next, I'm going to show only some examples because, trust me, there are a significant amount of documents proving this, but it would take weeks to go over all of them. But they all have been submitted to this court over the past 4 years. I am just going to pick out some and go over them. Please refer to Exhibit
Ryan?
37.
Help me out here. Where are you again? I still don't know where you are.
Exhibit 37.
Okay, so here's the deal. Just so you understand, I'm allowing you to do this reading, but it's all in the record, and all of the record that occurred prior to the last orders, I can't, there's no rehashing of that. We know what happened. That's why the orders are entered the way they are, is that you have control over his medical care. I don't understand why we need to read this. I want to be able to talk to you about what's going on now. I mean, you've read the history from back to 2016 when this case first started. I know a lot of those things happened. Some of the things you say were submitted were not. I mean, maybe you had them in your trial exhibits. They weren't entered in as evidence. I'm looking back as you refer to them. Some of them maybe were in your book, but you didn't have them admitted at trial. But a lot of them weren't actually filed. But again, you have what you're asking for. I'm trying to figure out what do we do going forward so that Alicio has the proper, continues to have the proper medical care, continues to have the proper daily care, continues to have the proper diet, and continues to have a decent relationship with his mom, if you think that's possible. You're saying that if he has a relationship with his mom, that his relationship with you is affected. But let me ask you this question before you get started again. Is there any appetite for letting me meet Alicio and Aliana? So I can talk to them myself.
Well,
That's
I would love to
Aliana's-
meet them because
Yes, please.
it's so helpful to be able to meet the people that I'm dealing with,
Please.
these children, and I know you guys love your kids, and I know that they've gone through a lot. I would really. I mean, I don't typically interview kids. We don't typically interview them. There's so many of them that come through the court, but this one really strikes me as one that I would like to meet both of them and hear from them
Yes.
as to, like, you know, what are their thoughts. And I'm going to talk to Alicio about his problem and you know how things have been going and his diet, and you know, I just think that would be really helpful. Do you think it would be helpful?
I do.
Do you think it would be helpful, Ryan?
now, like after he prevented me from
I didn't prevent
having-
you from
I
anything.
asked to have
Look,
them
I
to
looked at your
speak to
medical
before-
records. I have not prevented you from anything. You too, as parents, have gone into these doctors. I just read another doctor record. It said parents agree, dad and stepmom want to do this, mom wants to do that. Another record that said, you know, I can't deal with you guys because you don't agree, or mom's calling
There's
and
no
you need to
record
relay
stating
this
that,
information.
Your Honor,
What's that?
there's no record stating that, Your Honor.
I just read it. I read one of them
Which one?
from.
Where?
I can't remember, it was one that said that they recommended Botox. That was one of the other issues, recommending Botox. You and stepmom wanted to do the Botox. Mom said, let's hope he grows out of it. She wasn't on board with the Botox. I mean, I've dealt with all these treatments and these arguments over the treatments throughout the last 3 years. I know what went on here. That's why ultimately I gave you the decision-making power, because I think that you're the more vigilant parent on Alicia's diet. I know that you don't trust that she's doing what she's supposed to do. Even if Alicia says she's doing it, you don't trust it. So now he's in your care. And
so after the records, do you trust that she's doing the right thing after 4 years and having all these records?
I don't have all the
CPS?
see. That's where you brought a lot of records with you to trial. I think that you didn't admit at trial. So when you reference, well, this record was filed. It was not. This record was not filed. I did not have it. So a lot of the things that you're referring to, you know, looking backward, you might think that they're in the system. Some of them are. Some of them are not.
All right.
But
Okay.
But, again, I'm not allowed to go back and rehash and change orders or do anything. I know what happened. And I know you disagree with how it happened or disagree with the way the court did it, but you two come in here as joint legal and joint physical custodians. You were denied contact for 9 months. You got him when he was impacted. Mom testified that she would do what she needed to do to make sure that his diet was covered. She has a cook living in her house that cooks healthy meals. You didn't agree with that. Alicia had a guardian ad litem. The guardian ad litem said the stress of this case is affecting him. The doctor said the stress of this case is affecting him. Still didn't go away when the case ended. Because of that, the court granted you the ability to take care of him 90% of the time. Is he getting better? Because when you came back the last time, you said, not quite. You know, better but not perfect. Is it progressively getting better? That's my question.
And like I said, for like the third time, would you please save your questions till
No.
I'm finished? If we don't have time for me to do it today, I will request that you please set a special court date
This
so
was
that
a
we
special
can go
court
everything that I want to present to you.
This was a special court date, and you missed 30 minutes of it because you were late again. And I said it specifically so that you could come in and make your presentation without interruption. But I'm also absolutely permitted to ask you questions. My hearing. So I'm asking you, is he doing better since you've had him?
Since I've had him solely in my care, yes, he has been doing better.
Okay.
And I'll get to that
Okay.
more in detail.
All right. Go ahead.
Please refer to Exhibit 37. This is a medical record from St. Rose Hospital, July 25th, 2016. The defendant, the first day that she had Alicia in her care, after the very first court date, took him to the ER and former PCP, Dr. Pimento.
Yeah.
The highlighted portion in the results of the x-ray the defendant obtained on that day, it states there was moderate stool in the left colon consistent with stool impaction. Also, in medical records from Dr. Pimento, as previously been submitted to this court, Dr. Pimento referred Alicia to a gastro doctor for the second time, because the first time was in March 2016. The defendant proceeded to write to me on Talking Parents with the following statements on the second page of Exhibit 37, visit 72516. X-ray showed small amount of bowel due to constipation. Case is not severe and everything else is normal. The defendant also states to decrease dosage of Miralax for 1 to 2 weeks and then only continue if needed. The defendant also states Dr. Pimento wants to decrease Miralax and that Alicia needs to consume protein and that Alicia was old enough to move his own bowels. First thing that the x-ray showed that Alicia had fecal impaction, so it was severe, not the opposite. Second, there was no way that Alicia was to decrease and stop medications at any point, which is stated in Dr. Sheets' medical records, but the defendant clearly decided to ignore. The defendant did not mention once about Alicia being referred to a gastro by Pimento, just that he needed to move his own bowels. which is also false. Alicio was on a strict no meat and no protein diet due to the fact that it is very hard for his body to digest protein when he is severely impacted, which that diet plan is also recorded in Dr. Alha's records. The next record of false information given to me by the defendant was in regards to Alicio's x-ray on July 1st, 2016 that Dr. Sheik had done. The highlighted portion of page 3 states a moderate to large amount of retained fecal matter throughout the entire colon. If you go down to page 4, this is the talking parents message from the defendant that states in the highlighted portion, Dr. Sheik stated that Alicio's x-ray was normal and had no backup stool or signs of constipation, which Miralax is not needed. The defendant goes further even to state you should have gotten further medical instructions before continuing Alicio's medications. I already showed that once again. Another x-ray showed the exact opposite of what the defendant is stating to me, and she blatantly admits to not continuing Alicio's medication. Next time, we refer to the next page attached to Exhibit 37. The defendant's own responses to my admission request, the highlighted portion 34, number 34, admit that you and your family tell Alicio that he is fine, healthy, and there is nothing wrong with him. The defendant admitted to that question. The next question was number 35. Admit that you would tell Aliana that Ryan and his wife were lying about Alicio's condition. The defendant admitted to. So the defendant would willfully and purposely lie to Aliana in attempts to distort her image of me and my wife. The defendant admits that she tells both of the children that there is nothing wrong with Alicio. So why this court would believe that the defendant is going to take care of Alicio's medical conditions is beyond me, because she clearly does not believe he has any medical conditions. Still going along with the same exhibit, just
Are you?
going to the next
I don't
page.
understand, because I've just told you that I gave you I mean, are you just complaining?
Yes.
I mean,
No,
because I gave you the
From
right to do
2016.
this. So I mean,
Before-
look,
Your Honor,
I gave you both the ability to step up to the plate and do what was right for Alicio. I believe that you're the one that now should have that right to do that yourself. And so I'm trying to figure
Okay.
out what is the purpose of going backward.
because before you gave me the right to do this,
Yeah, you
you
had
made
both had the
final
right.
orders
You both have the right.
in January of 2000 or December
Mm-hmm.
2018, or it was January 2019 of this year. Your final orders. You gave her more time, and you gave her the right to do everything.
Well,
and you
I think
gave
that
me
was during
three.
during the week, right? Because you were working.
Whether I'm working or not, I have an intact family unit at home. I have someone that takes care of my son when
does
I'm
she.
not there. So it doesn't mean because I was working, you gave her the time to do the thing. No, it's not how it goes.
Okay.
Still the same exhibit. Scrolling to the next page. This is a copy of Talking Parents' message from the defendant on August 22nd, 2016. Exactly 8 days before Alicio was admitted to UMC for an aggressive cleanout, the defendant states, Wendy referred specialist, which then I was informed that Alicio does not need to do any specialist treatment, and his pediatrician will be able to proceed with further medical treatments due to his last report and x-rays by Dr. Sheik. The defendant then continues to state, it now seems that you try and find anything wrong with them to tell it from your point of view to make me look bad. Now as to the facts. First thing is, Wendy was Dr. Barron's office manager at the time. She most definitely was not a referred specialist. So that was the first lie. Second, the defendant's statements in regards to Alicio not needing specialist treatment. Clearly, the x-ray done by Dr. Sheik completely states otherwise. If he did not need specialist treatment, then why would Dr. Sheik refer Alicio to another gastro instead of his PCP? That makes lie number 2, just in those 2 lines. Third lie was defendant's statement that I tell it from my point of view. Also false. I relay and attach all medical records from all appointments, so not one recommendation came from me. It came from a doctor. This is the third time within 1 month time span that the defendant has proven to this court that she will not follow a treatment plan because she does not believe there is an issue. Next, if you scroll down, it is the record from Dr. Alhaj on August 18, 2016, where he states high fiber, no meat. Right below that is an Instagram post by the defendant's mother that clearly states her disregard for Alicia's treatment plan by allowing Alicia to eat protein, and then mocks the doctor by stating, "Doctor said he couldn't eat protein. Of course he can." The next page is a talking parent's message from myself to the defendant. I explained to the defendant what the plan is that the doctor put in place in an attempt to clean him out. I stated, "I'm going to give Alicia prescription Miralax every hour until his poop is clear. He is not to have any food during this process, and he will only be allowed to have liquids such as jello broth, and if it does not work, then he will have to be admitted to the hospital and kept overnight. A tube the size of a spaghetti noodle will be inserted through his nose, down his throat, into his stomach to be flushed out." The defendant, of course, had no response, but wrote me regarding school. I stated to her, "No response to Alicia's medical, but you can respond to school stuff." The defendant clearly still did not believe the doctor when they stated he would have to be admitted to the hospital if this did not work. I always have been very, very thorough when submitting medical records and all information to the defendant, but she has never done the same in return. Now on to the next page that includes the talking parent's message of the defendant on September 7th, 2016, stating to me that the doctor and x-ray at Sunrise Hospital on September 7th stated that Alicia was fine and almost cleared out. Now scroll down to the next page, the actual records from Sunrise stating the results of the x-ray, full incontinence of feces. Then the next page stating moderate to large volume of fecal material is seen throughout the entire colon. The only reason why I found out the truth because I arrived at Sunrise right as they were being discharged. The defendant lies about the time she got to the hospital. She states she got there around 6:30 or 7, when truth by the record is 4:55, so immediately right after court. I stayed behind and talked to the doctor, and she went over the results with me, and the doctor explained to me that she has no idea why Mom would say he was almost cleaned out, because she explained the same to Mom that she did to me. 2 days later, September 9, 16, was the first that Alicia had been admitted for a clean-out. This is exactly what we were trying to prevent from happening. This is not something that should be taken lightly. It is not like the defendant is just lying, for example, if Alicia did not do his homework or not. This is something serious that has to do with Alicia's health that she is lying to me about, that could have very severe consequences on Alicia. Next, if you scroll down, you will see talking parent's message from the defendant in regards to Alicia's bladder medication. The defendant was trying to state that the pharmacy was refusing to fill her prescription for oxybutynin due to the fact that I had already filled my prescription.
What date is that?
This also,
Pardon?
I said, that's true.
What day is that? What number is it?
that is
I think my attorney submitted the letter from the pharmacy
defendant,
long time ago.
8/22. The
8/22
talking
of what?
parent's message from
What exhibit is
August 8/22/16.
it? Of 16?
No. It's a talking parent's message on August 22nd, 2016. I believe it's 37.
Okay.
Exhibit
Again.
37.
Okay.
So,
We only have 15 minutes and then my next hearing starts. I mean, I can take a break and do that one, and then we can take a little more time after that, but that's it. So, and then we need to talk
Sure,
about
it's
what the
not at
future
1
orders are
o'clock?
gonna be. Cause again, a lot of these things, if you attempted to bring them up at trial, when you say this was already submitted, a lot of these were not submitted. They were, I think, part of your many notebooks at trial. A lot of those exhibits weren't admitted at trial.
you have
Um,
what at 11?
I have a hearing at 11. I have a telephonic hearing. So I'll just have you guys step out and I'll make the call and then I'll have you step back in. Because I believe that's a sealed case.
Okay.
Yeah, it's a sealed case.
So
So,
she was trying to state that she could not fill her prescription of oxybutynin because I had already filled mine.
right, we
This
went
is
through all that.
also completely false. I called 2 different Smiths, and the pharmacists both told me they could fill 2 prescriptions because they are for different households.
But didn't
the
we already
only
deal with all
thing-
this? We dealt
the
with all
only
this, Ryan.
is
Some of
that
the stuff
when-
you can skip because we've dealt with all
It
this.
it's because she's lying. She's trying to say she couldn't feel it. Because
But
she
we
wanted a
already
reason
dealt with
to say-
that. We dealt with that in one of the many hearings
Okay,
where we
well,
ultimately figured out how to get them this prescriptions filled. I mean,
No.
look. If,
Okay, then I'll skip that part.
Okay, please.
On the next page, you will see yet another talking parent's message from the defendant on the medical records from when she took Alicia to Southern Hills ER 2418. The defendant states to me that she took Alicia to the ER because he was complaining of acid burning sensation in his chest and chest pain and that he vomited a tiny bit. She states that she was concerned he was going through his compaction issues again, but thank God he was not, and that he was significantly better and only full of gas due to the medications already taken. She also stated that doctor didn't mention anything about being compacted. Now, what is surprising to me, that the same day Alicia was taken to the ER, he spent the entire Saturday with his grandmother, going to the strip and a triple birthday party, which was documented on the grandma's Instagram, boasting about it. Then if you scroll down to the actual medical records from Southern Hill, it states the highlighted portion: chief complaint, abdominal pain, context of onset, eating, location, lower abdomen, painful, nothing relieves the pain, reports diarrhea and vomiting and constipation. Interesting is when asked about chest pain, it states denies. Wasn't that the reason the defendant gave to me as she took him there? Next page states distension of his abdomen. Next it states primary impression, abdominal pain. Then it states the patient is constipated and actually prescribed Alicia a laxative. Alicia was also put on the clear liquid diet for 24 hours. Once again, the defendant is lying about what is being stated from the doctor visit. There are so many more, and there would not have been enough room or time to even go over all the different times. How am I supposed to trust the defendant to relay any correct information to me or records from any doctors or any updates of treatment plan if she has proven without a doubt that she never will? The defendant puts Alicia's life in danger with her negligence. I would never trust her to take Alicia to the doctor, seeing as she has proven by her own actions that she will not ever tell the truth. She must suffer from liarrhea because everything that comes out of her mouth is a lie. When the defendant states in her motion, this was completely unfair,
wasn't
as I should have
why
all
would I-
rights
why
to
would I
be
take her
there.
to
The
the
defendant is referring the defendant is referring to the out-of-state gastro appointment on 10/4/19. Now, the defendant most certainly should not have any right to be there, seeing as all she ever does is interfere with the treatment plan and reject all the doctor's treatment plans. She has harassed the doctors here to the point where no gastro will see Alicia here. Even after his PCP Weiner called and was asking the gastro doctors to reconsider and see him, none of them would due to the mother's harassment. Please refer to Exhibit 15. The urologist emails me stating, Alessa
the
is
only
coming to our
doctor
office
that I
to
ever
try and get
contacted.
records and is sending multiple text messages and making phone calls.
This is Dr. Wong you're talking about, right?
It is highly disruptive,
Wayne.
just
Wayne?
like she's doing right
Okay.
now.
I
If you are
stop it,
unable
Ryan.
You don't
to
have-
come
I'm asking the
to
question. Okay,
Yeah.
so I saw his text, so we can skip it. I saw his message and I
Yeah.
read that. I completely understand it's hard on Alicia. I'd like to see less of the discord. So would the judge. That's why she made the orders the way she did.
If
you
you are
don't wanna
not
shun
able
his
to
mom.
come to a common plan, I would
Right,
consider
yeah, I just
discharging him
never-
from our practice. I then replied
might
to
have
Dr.
told him.
Wang with the screenshots
So-
of talking parents' messages of me sending the defendant with the records, and that she already had the records when she was harassing the doctor. I stated to him, I highly apologize, and I will be informing the judge immediately of her behavior, and that I was thoroughly embarrassed by her actions and behavior. The doctor then replied to me, Dear Ryan, thank you for your understanding. I see hope that with your help, we can get Alicia significantly better. Take care. Poor Dr. Wang lost hope for Alicia, and once I showed him the truth,
I read
that
all
I
this
do
already.
in fact notify the defendant of all records, he regained hope back for Alicia. The unfortunate aspect for Dr. Wang is that I told him that I would notify this court, and when I do, this court blatantly disregards the defendant's behavior. The fact that Alicia was almost discharged from another doctor. Now I will move on to Exhibit 18, which are the emails from Dr.
I
Wang
don't know when he's
in
talking about
regards
how it was
to
disregarded because he
Alicia
was given
June 4th,
custody or
2019, because I submitted those emails saying that he was considering discharging Alicia
But I never
because
went into
of
the office.
her
But she's
actions.
okay, so here's the problem, and we already addressed this. That way you can
No.
take him to the
No.
doctor. Mom's still entitled to the information. You need to make sure she has the information because she's still entitled. So, unfortunately, thankfully, he didn't
has
discharge him
been.
though.
She has been. She has everything, and that's on Talking Parents.
I understand.
Yeah, after
Dr.
every
Wang
appointment,
states
but you
in
never
an
tell me.
email to me, I understand. I just want to get Alicia well as soon as we can with as little interruption from family discord as possible. If such situations prevent us from taking proper care of Alicia, I may need to ask you to consult with another urologist. I then responded to Dr. Wang and stated, I completely understand it is very hard on Alicia, and so I would also like less of the discord, and so would the judge. That's why she made the orders the way she did. I did not want to shun his mom from appointments, but I feel if she wanted what was best for Alicia's health, she would have stayed for the appointment and listened to what your recommendations were, and she did not do that. I promise you it will not happen again. We appreciate everything you have done for Alicia, and we do not want to lose you as his urologist. And Alicia is very comfortable with you, so I would hate to change his doctor after 3 years of being under your care. Dr.
That's
Wang
another
responded to
thing.
me,
He's
I agree,
treating
take
you
care.
for
The
bowel
doctor
stuff, too,
agreed
as
that
well
if the
as he's
defendant
just a
cared, she would
urologist.
have
Stop.
stayed for the appointment. He agreed with all of my statements. I
Okay.
also have a video
Hold on.
from June.
Hold on. I already read this part, so hold on one second. I lost where you were. Where's it part about he agreed with all of my statements? Oh, there it is. I also have a video from June 4th appointment where Dr.
Where he
Wang
states
states
before he walks out that what is best for Alicia is that everyone who takes care of him stays, so we
We're
are on the same page.
Mm-hmm.
The defendant does not care about Alicia's health or appointments, as she has proven it over and over again. So why to this court would still believe that the defendant does, after all of her actions, prove otherwise is
I
beyond
don't know
me.
why you make these statements,
This
Ryan. I
court-
changed the rule. I changed the orders, but okay.
And
So hold on. We're going to take a break because your point is, I've got your point, and I have to call the 11 o'clock, so I'm going to have you step out. 1, 2, 3, 4, 5, 6, 7, 9, 10. There's like 20 more pages. We don't have time to listen to 20 more pages. Okay, so we're going to go off the record and
Sometime.
we're going to talk about what we're doing going forward.